Hello and welcome to the second installment of the Canadian Legal Aspects of Security. Now in our last program we gave you a broad overview of the law covering what the law is, sources of Canadian law, types of law, and the court system in Canada. In this presentation we'll deal with legal situations that you are likely to encounter during your career as a security officer. We will cover authority of security officers, arrest, trespass and dealing with trespassers, search and seizure, and torts. Now, our instructor is Dave Ray, Director of Western Canada for Kroll Associates, a world leader in security of the corporate sector. Let's join him now.
Let's talk about the authority of security officers. In the course of your duties as a security officer, you will exercise powers granted to you by law. Given this reality, it is imperative that you understand your authority within the law, your duties, and your responsibilities. As a security officer, your authority comes as an agent of the owner or person in lawful possession of the property. The law recognizes the right of the owner to protect the use of their property. Generally, a contractual agreement provides the authority for you to act as an agent of the owner. If you are an employee of the owner, the employment contract is implied. If you're a contract security officer, the agreement is usually in writing. In the ideal situation, you'll have a set of written operating procedures and ongoing written directives that establish your duties and responsibilities. At times, the directives are verbal. If instructions are verbal, you should maintain a record of the details in your notebook. We'll first talk about arrest. In effecting an arrest, a police officer, private citizen, or security officer is depriving the freedom of another individual. The whole area of arrest is extremely complex, but important to understand. Under most circumstances, an arrest will not be necessary in security incidents. However, a security officer may be put in a position where an arrest is necessary to identify the accused, to recover stolen property, or protect evidence in the possession of the suspect, or where a person is drunk, violent, or suicidal, to protect that person or others. What constitutes an arrest? The courts have held that there need not be the use of handcuffs or laying of hands on a person in order for an arrest to be complete. A restraint by an assertion of authority may be sufficient if the person submits to being deprived of his liberty. Under the right circumstances, the words "come with me" may be sufficient to constitute an arrest. Sir Patrick Devlin stated, "Arrest and imprisonment are in law the same thing. Any form of physical restraint is an arrest, and imprisonment only a continuing arrest." Whether an arrest has been properly effected may be important for two reasons. Firstly, if the person being arrested resists, they may be charged with resisting arrest, but the Crown must be in a position to establish that it was a lawful arrest in the first place. Secondly, if there is a civil action for a false arrest, the plaintiff must be able to prove that there was an arrest that caused a loss of liberty. Let's talk about citizen's arrest. Can a security officer in the course of duty use the power of a citizen to arrest? The obvious answer is yes. The rights and duty of the citizen to effect an arrest were established at common law in early England before there were police officers. That right was codified in Canada's Criminal Code and provides that anyone may arrest without warrant, firstly, a person whom he finds committing an indictable offense, or secondly, a person who on reasonable and probable grounds he believes has committed a criminal offense and is escaping from and freshly pursued by persons who have lawful authority to arrest that person. It's unlikely that the average citizen could make an arrest based on the first section, since the average citizen will probably not be able to differentiate between indictable offenses and summary conviction offenses. The trained security officer, however, could do so. You've already learned that indictable offenses include more serious offenses such as robbery, murder, theft, break and enter, etc. They do not include less serious offenses such as willful damage and motor vehicle or liquor offenses. Where the offense is dual procedure, such as assault, you have the right to assume it is indictable. The second section allows for a citizen to effect an arrest where a police officer is actively in pursuit. Now, what about procedures in effecting an arrest? Once you've made a decision to arrest someone, a security officer must proceed in an appropriate manner.
Sir, you're under arrest.
Firstly, tell the person that they are under
You have the right
arrest.
to retain and instruct counsel without
Secondly,
delay.
tell them
This
the
means
reason for the
before
arrest.
we proceed with our investigation, you may call
Thirdly,
any lawyer you wish,
inform them of
or
their
get
right
free
to
legal advice
retain and
from
instruct
duty
counsel without delay.
immediately.
And
If
that
you want to call duty counsel,
duty under the
we will
Canadian
provide
Charter
you
of
with
Rights and
telephone
Freedoms in
telephone
Section
numbers.
10.
If you wish to contact any other
Once you have arrested them, turn them over to the local police as soon as possible. In most cases, this means that the police will be called to attend and pick the person up. Protect the person from harm until the police arrive. Where the person is suicidal or under the influence of drugs or alcohol, there may be a necessity to use restraint in order to provide protection. Let's look at that scene again and review what you should be doing.
Sir, you're under arrest. I'm arresting you for theft. You have the right to retain and instruct counsel without delay. This means that before we proceed with our investigation, you may call any lawyer you wish or get free legal advice from duty counsel immediately. If you want to call duty counsel, we will provide you with the telephone and telephone numbers. If you wish to contact any other lawyer, a telephone and telephone book will be provided. If you are charged with an offense, you may also apply to legal aid for assistance. Do you understand?
Yes.
Do you wish to call duty counsel or any other lawyer?
No.
Remember that an arrest is the restraint of an individual by assertion of authority. It can be as simple as telling someone to sit down while you call the police. Next, we'll talk about arrest for breach of the peace. A breach of the peace is an unusual occurrence that disturbs the normal routine found in any given location. For example, a fight breaks out in the lobby of an office building. That would be a breach of the peace.
Hey man, you got that $200 you owe me?
Money? I don't owe you any money.
I want that money today.
Hey, listen.
I need that money
As a
today.
matter of fact, you owe me money.
I want that money.
You're not getting any money.
Hey guys, what's the problem here?
Nothing.
Okay, I'm gonna have to ask you to leave. Hey, this way.
The power of arrest for breach of the peace is found in Section 30 of the Criminal Code. It allows any person to detain someone who is in breach of the peace or is about to join in or renew a breach of the peace, and it requires no more force than is necessary to be used to prevent the continuance or renewal of the breach. Section 175 of the Criminal Code specifies activities that constitute causing a disturbance. It includes fighting, screaming, shouting, swearing, singing or using insulting or obscene language, being drunk, impeding or molesting others, loitering, and obstructing others. There's another power of arrest of a property owner. The Criminal Code provides for this second and more useful power of arrest, and it can be used by security professionals. It states anyone who is the owner or person in lawful possession of property, or a person authorized by the owner, or by a person in lawful possession of property, may arrest without warrant a person whom he finds committing a criminal offense on or in relation to that property. The big difference with that section is that it allows the person authorized, for example the security officer, to arrest someone for any criminal offense, summary conviction, or indictable. For example, if someone breaks a window and commits the offense of mischief, the security officer may arrest them even though it is a summary conviction offense. We should also look at some of the issues regarding juveniles. When arresting juveniles, you may fall under the Young Offenders Act. You have the same authority under the Criminal Code and the same duties. Special precautions, however, must be taken to protect the identity of the young person in your reports and in your discussions with others. Reports may be prepared for the administration of justice, but they should only be provided to the police and should be secured under lock and key. What about the use of force? One of the most difficult questions in the area of arrest is how much force is appropriate to effect the arrest, restrain the arrested person afterwards, or stop them from escaping. Obviously, the reasonableness of the force will depend on all of the circumstances surrounding the incident.
Dispatch 3458.
Go ahead.
I've got a 1049 in progress in lot 3. Subject is going to be moving southbound through the lot away from a white Suburban. Subject is going to be wearing a red jacket, dark pants, dark footwear, dark gloves, and carrying a duffel bag in his right hand.
10-4, 58 and I are in the area, we'll respond.
10-4. 3458, be advised I have him on view.
Sir, I need to talk to you for just a second.
What for?
Because I have a witness that says you broke into the vehicle and you stole the bag.
I just walked by that truck and that's my bag.
Do you have identification to show me that that's your bag?
I don't have to show you identification.
You have to show me identification, sir. Sir, you're under arrest for breaking into the vehicle and stealing the bag.
To prevent a charge of assault by the person arrested, the officer may use only as much force as is necessary. If the force is necessary, the security officer should only use a restraining type of force. Once an offensive type of force is used, such an attempt to incapacitate the prisoner, then there is a stronger likelihood that the person arresting is stepping beyond reasonable force. Let's talk about protection of persons acting under authority. The Criminal Code states that everyone who is required or authorized by law to do anything in the administration or enforcement of the law as a private person is, if he acts on reasonable and probable grounds, justified in doing what he is required or authorized to do, and in using as much force as is necessary for the purpose. This section effectively removes liability from an authorized person who uses reasonable force to enforce the law. In other words, if an arrest is justified, you may use reasonable force and not be held liable for it. I'd like you also to understand some of the rules of evidence. Now, what is evidence? In criminal law, evidence is the proof that is required to establish the guilt or innocence of the accused. Evidence may be one of several things. It may be real, a physical object like a gun or a piece of stolen property. It can be documentary, a record, a contract, or a bad check. It can be testimony, any oral testimony of a witness while under oath. Evidence can be either direct or circumstantial. Evidence is direct when a witness can testify to what was observed through the five senses. Evidence is circumstantial when it infers another fact. For example, testimony that a witness saw the accused draw out a gun, pull the trigger, and then saw the victim fall to the ground dead after the shot rang out is direct evidence. Testimony that the witness saw the accused standing over the dead body of the victim with a smoking gun is circumstantial evidence. The witness did not see the murder committed. Contrary to popular belief, circumstantial evidence is admissible. In fact, most evidence entered into court is circumstantial. It is the responsibility of the witness to relate the facts, and it is up to the judge or jury to decide whether circumstantial evidence leads to an inference of fact that would convict the accused. Now about protecting evidence. As a security officer, you may be required to protect evidence at a crime scene. It may be as simple as a broken window or a ransacking of an entire facility. Once you detect a crime scene, it's your responsibility to ensure that you protect and preserve the scene and report your observations and actions appropriately. The best way to protect a crime scene may be as simple as locking a door or as complex as using extra manpower and barricades. In any case, the method you choose must keep people out until the police arrive, in order to prevent tampering or destroying any evidence that was left behind. Protecting evidence also means preserving it in exactly the same condition that it was left after the crime was committed. Nothing can be moved, removed, touched, added, or altered in any way. This means you too. In other situations, you may have real or documentary evidence without a crime scene. Any real or documentary evidence must be protected from the time that it is obtained. It must be saved in its original condition. Some sites have a locker or cabinet or a room specifically for secure storage of evidence. The best evidence rule applies. In other words, if you have the original document, that is the one that should be provided as evidence in a court of law. Otherwise, the next best is used. Some suggestions for preserving documentary evidence are: don't write on or mark any documents, make your notes separately or photocopy the document and make your notes on the copy. Don't handle original documents unnecessarily. If you need to work with them, make copies and work with the copies. Don't perforate them to place them in binders, and don't staple them. A good way to protect documents is to place them in a plastic page protector or in sealed envelopes. If they're available, do not dispose of envelopes that the documents came in. Save them as you would any other document. For items other than documents, don't handle them excessively and do not mark them. Store evidence in a secure place until the investigator is able to make other arrangements to secure it. The final step in protecting evidence involves taking detailed, accurate notes of everything that you observed. Make your notes during the investigation or immediately after, while it is still fresh in your mind. These notes will be the foundation of your report of the incident and may be required as evidence if the culprits are caught or tried. The judge will place a great deal more weight on testimony where your memory can be refreshed by notes. The time between an incident occurring and a trial can be measured in months or years. The importance of detailed, accurate notes cannot be overemphasized. Let's talk about hearsay evidence. The general rule for hearsay evidence is that assertions other than those of the witness who is testifying are inadmissible. An example is an attempt of a witness to repeat what another person said. The rule is that the court should hear the testimony from the person who uttered the words. However, having said that, most rules in law have exceptions, and the rule of hearsay is no different. A few of the more notable exceptions are things like business and banking documents. They may be admitted into evidence as a truth of the contents without the necessity of a human witness. Under some statutes, affidavits and depositions are admissible in court as truth of their content. Admissions and confessions are another example. They're evidence in court only if they are first proven to be voluntary. Let's talk about confessions. A confession is a written or oral statement not made in court against the interest of the accused. For confessions to be admitted into court, there can be no threats, intimidation, or promises to the accused which may induce him to make the statement. The confession must be voluntary. The security officer may receive a confession from an accused in the course of investigating an incident. It does not have to be a lengthy statement in writing. It may be a simple oral statement like, "I shouldn't have taken it." As a security officer, you must note any statements made by the accused. If this will reduce confusion later in court as to exactly what was said. Notice how this security officer handles a confession.
I shouldn't have taken the wallet.
Okay, so you're telling me that you took this?
Yeah.
Do you have some identification, sir?
Yeah, I do.
Could you pass it to? Okay, I think what we're going to do now is have you accompany us back to our office, and we'll discuss your options, and we'll discuss this further.
All right.
Here are some guidelines for you to follow if you receive a confession. Don't make or imply any threats or promises. Ask questions that are direct or pointed. If you ask ambiguous questions, the accused may later claim that he did not understand. Give the accused time to explain. Do not be aggressive or abusive with the person being interviewed. The next area I want to talk about is burden of proof. The burden of proof that is necessary to establish an issue will vary depending on the nature of the issue and the forum where it is being heard. Society demands a higher burden of proof where the repercussions are greater. The balance of probabilities is the lowest burden of proof. It applies to the adjudication of civil issues between two parties and to labor arbitration for cases not involving dishonesty. For example, termination for poor performance. The burden is on the plaintiff to prove the issue at a civil trial. It is on the employer at arbitration. Beyond a reasonable doubt is the highest burden that can be applied to a trial of an issue, and it's reserved for the burden imposed on the Crown to prove the accused guilty at criminal trials. A preponderance of evidence applies to the review of dishonesty cases at arbitration. It lies somewhere between the balance of probabilities and beyond a reasonable doubt. Again, the burden is on the employer to establish the case. An arbitration panel is not bound by formal rules of evidence, and the only grounds for appeal are procedural issues. What if you're asked to give evidence? Chances are that sometime during your career as a security officer, you may have the occasion to appear in court on behalf of the client or the company you're working for. The prospect of appearing in court can be unnerving without an understanding of the justice system and the court procedure. Here's a few guidelines to help you bolster your self-confidence. Firstly, know which courtroom you'll testify in. Check it out in advance and be sure. Know who the major players are, the judge, the prosecutors, and the defense counsel. Don't discuss anything about the case in public, and don't discuss your personal life in public. It may give people an opportunity to judge you badly. Be professional and polite at all times. Always be on time. Dress appropriately, businesslike and official. If you're in uniform, be sure it's clean, neat, and complete. Court procedures aren't as they appear to be on TV. There are straightforward rules that ensure that orderly and predictable events in the courtroom occur. When giving evidence, remember these points. Be serious at all times. Speak slowly, clearly, concisely, and courteously.
Ms. Taylor, would you please describe the accident scene and the vehicles as they were when you arrived?
Which vehicle are you referring to?
Start with the car, please.
The car was a 1994 white Tempo, damaged to the passenger side.
Don't nod your head and answer questions. Say yes or no. The court reporter can't transcribe a nod. Avoid nervous habits like fidgeting. Consider the question before you answer to be sure you understand it. If you're not sure, ask for clarification.
Did you speak to any witnesses at the scene?
There were several witnesses. Which one are you referring to?
The driver of the car.
Yes, I spoke with him.
Answer all of the questions truthfully. Stick to the facts. Don't give your opinion. Don't frown or scowl at the defense counsel or the accused. If you don't know the answer to a question, say so.
Was the cause of the accident the car going through the intersection?
I do not have that information. I did not witness the accident.
Remember that you're there to give evidence about what you saw, did, or heard. The decision as to guilt or innocent is the court, not yours. Trespass is an important issue for you to understand. The right of any owner of property to control the use of that property and protect it gives security officers considerable authority. The owner can and generally does impose conditions which people must abide by when on the property. For example, a retail store generally expects shoppers to frequent the premises. If a panhandler takes up begging within the store, the owner will likely ask them to leave and has the power to insist that he comply. Should they refuse to leave, the owner may have them arrested or for trespassing. There are three ways to deal with trespass. Firstly, as a civil action. Secondly, under a provincial statute, for example, a Petty Trespass Act. And thirdly, as a criminal code offense under Section 177, trespassing at night. Provincial trespass acts usually indicate the method of providing notice, for example, by word of mouth, in writing, signs, etc., the placement of the signs, the powers of arrest, and fines. It is necessary for security officers to be familiar with trespass legislation in their jurisdiction. The normal defense to a charge under a provincial statute of trespass is fair and reasonable supposition of right. Now, what about search and seizure rights? When is a search permitted? The authority to search at the time of an arrest is vested through the criminal code. A police officer has the right to search a prisoner at the time of an arrest, and the courts have confirmed that right on the private citizen, and therefore security officers. However, it would be wise to avoid a search unless it is necessary to protect the prisoner or others, or to recover evidence that the prisoner may possess. If the police will be immediately involved to take custody of the prisoner, the security officer should consider waiting for their arrival and for the police to conduct the search. The reason is that if the security officer went beyond his authority, the search may be deemed improper and a court of law may not admit the property as evidence at trial. Searches are also permitted at any time if the person being searched gives permission to do so.
Hi, excuse me, sir. I'm with security of this building complex, and we have a report of you carrying an illegal weapon. I'm going to detain you. However, I need to search you, if that's okay with you.
Okay.
Okay, please turn around slowly. Put your hands on your head. Open your legs. Lean forward slowly. I'm now conducting a search on you. Okay, Jason, I think I found something. Come over to my left. I am placing you under arrest for carrying a concealed weapon. You have the right to retain and instruct counsel without delay. Do you understand?
Yes.
However, if during the search the person withdraws his consent to being searched, you must stop. If you continue to search under those circumstances, you are committing assault and you can be charged accordingly. Follow the procedures established by your employer or the owner of the property for specific sites. And what about searches at the workplace? What about the right of security to search at a work site on behalf of the employer? These searches are usually conducted on employees' lockers, lunch buckets, or purses, vehicles, or other personal effects as part of an investigation or in conjunction with a company policy like the restriction of drugs or alcohol in the workplace, or a policy prohibiting employees from keeping company property in their lockers. Here's some guidelines for searches in the workplace. The search must be reasonable. There must be evidence that the offense took place, or there is a reasonable potential for loss and that the search will provide substantiation of the offense. The search policy should be applied consistently and should not be a target of a particular individual or a department. When searches are conducted in the workplace, they should be conducted in a uniform manner. There should be evidence of their necessity, and there should be respect for the employee's rights to privacy. Be respectful of those being searched. Remember that even when a person has willingly consented to a search, it's still an invasion of privacy, and emotions can run high. What about searches of vehicles? The employer may set up search procedures as a condition of employment, or a search may be a condition of entering on company property, announced by a sign posted at vehicle entrances. These searches are considered consensual and voluntary. However, the consenting party can withdraw consent and refuse to have their vehicle searched. If a security officer forces a search after consent is withdrawn, the searched party may commence a civil action against the company and security staff. If consent to search is withdrawn and a search is not undertaken, security staff and the company can respond as follows. If the person is a visitor, he or she may not be allowed back on site. If the person is a salesperson or a subcontractor, their company can be contacted and advised that they will not be allowed back on site. If the person is an employee, treat the issue as a disciplinary matter for failure to follow company procedures. Once in a while, a security officer will be involved in a search under warrant. The Criminal Code provides that a justice of the peace may allow a warrant to name a person other than a police officer to assist the police with their search. This is done in circumstances where the police require outside expertise or ability. For example, in a search of a residence for stolen company property, a security officer employed by the company may be named in the warrant to attend in order to help identify property that may have been stolen. Security personnel should only assist the police with a search if it is company property, they are specifically named in the search warrant, the property owner has given specific authority. Now, I mentioned torts. What are torts? Torts are defined as a civil wrong for which the remedy is a common law action. It is not exclusively the breach of a contract or breach of trust or other merely equitable obligation. Torts are either intentional torts or negligence. With intentional torts, the action results from a deliberate act where the person knew or should have known the consequences. In negligence, there is a failure to use due care and attention. Okay, intentional torts include a number of things. Assault is one. Assault is intentionally causing another person to fear imminent contact of a harmful or offensive nature. There need not be actual physical contact. Battery is another. Battery is intentional, actual harmful contact, and that may range from just shoving someone to actually inflicting harm. A third is wrongful imprisonment. And wrongful imprisonment is sometimes referred to as false arrest. It takes place when a person is constrained without justification. It's the prevention of someone leaving the place that they are in, and it's an arrest without lawful authority. Another is intentional infliction of mental suffering, and that's conduct that intentionally causes severe emotional distress. Conversion is another. Conversion is the civil law counterpart of theft. It's the intentionally exercising control over the property of another without the authority of that person. Fraud is another. Fraud is the civil law counterpart of criminal fraud. It involves deceit or injurious falsehood. There's two types of nuisance. Private nuisance is the interference with the use or enjoyment of the property of another. Public nuisance is the interference with a public convenience or welfare, for example, a highway. Both are an activity or physical condition which cause harm or annoyance. Defamation can be either an oral statement, which is slander, or a written statement, which is libel, and it's basically untrue and causes damage. Malicious prosecution is instituting criminal proceedings maliciously or for some purposes other than enforcement of the law. It is without reasonable or probable cause and causes injury to the plaintiff. Okay, now I mentioned negligence. Negligence is a failure to use due care and attention. It's conduct which does not meet the standard required to protect others from the unreasonable risk of harm. A significant portion of liability exposure to you and your company will come in this area of the law. There is a duty to protect against unreasonable risk and injury. As a security professional, there is a higher degree of duty than an ordinary person, and you must act to the level of skill that is generally accepted in the profession. In order to prove negligence, there must be a breach of duty. In other words, it's necessary to show that the action taken was unreasonable and caused damage to the plaintiff. There are many instances in the workplace where negligence can be claimed. They include negligent hiring. An employer may be liable if they knowingly hire an employee who was unfit for employment, and that employee caused damage to a plaintiff in the course of the employment. Negligent retention. An employer may be liable if they continue an employment relationship knowing an employee is potentially dangerous, and that employee causes damage to the plaintiff in the course of employment. Duty to maintain a safe work environment. An employer may be liable if they do not respond to risks or potential danger to an employee, visitor, or customer. A duty to warn. An employer may be liable if they become aware of potential danger and they fail to warn their customers, employees, and visitors of that danger. And a failure to document behavior. An employer may be liable if they fail to document negligent or poor behavior of an employee and that employee is dismissed or disciplined for that behavior.
Okay, I need to talk to you here for a second. We have a witness who saw you break into this vehicle over here and steal that bag.
It's my bag.
That's your bag? Do you have any identification?
Well, I don't have to show you identification.
You need to show me identification, sir.
I didn't do anything wrong.
Okay. There's no need to push, sir, okay? What I need you to do is to cooperate with me. You're being placed under arrest for breaking into the vehicle and stealing the bag. You're gonna come back to the office with my partner and I, and we'll get this cleared up.
All right.
As a security officer, you are the eyes and ears of your employer or customer. Accordingly, you have the responsibility to report dangerous situations that you become aware of. Negligence cases have more to do with the facts surrounding the case, and the existence of negligence is a decision of a judge or jury. In these videos, we've provided you with an overview of the law as it pertains to the security profession. We've dealt with legal situations that you're likely to encounter during your career as a security officer. Security is a demanding job that requires considerable understanding of the legal issues. It's up to you to become familiar with the law and to reduce the liability of you and your employer. By studying these presentations, you have taken the first step to achieving this objective. Thank you for joining us.
Well, that concludes our look at the Canadian legal aspects of security. Thank you for joining us, and we'll see you next time.